Hello everyone, I Tanya Giri and today we'll be discussing the case law Maneka Gandhi versus Union of India. Let's move forward towards the introduction part. So this case analysis aims to analyze the Supreme Court landmark decision in Maneka Gandhi versus Union of India 1978. The goal of this case study is to demonstrate how the judgment has expanded to the reach of Article 21 of the Constitution and altered the face of Indian legal system. Article 21 of the Constitution declares that personal liberty is freedom from all legal constraints, and this scenario is not exclusively deals with the interpretation of Article 21 of the Indian Constitution, but it also demonstrates the relation between Article 14, Article 19 and Article 21 by giving a new perspective on Chapter 3 of the Indian Constitution. Now we move forward towards the historical overview of this case. The primary question in this case is whether due to process model is the same as the procedure set by law set by legislation, and it was determined that Article 21 did not oblige the court to apply the due process model. Following this case, the Maneka Gandhi case overruled the judgment by holding that the procedure set by law should also comply to the principle of natural justice and give residents of India with a broader interpretation on fundamental rights. In case Satwant Singh versus Assistant Passport of Officer, Government of India, 1967, it was held that the freedom to go abroad is protected by Article 21 of the Indian Constitution, and a person's passport cannot be denied if there is no law governing in it. By following this decision, the Parliament created the Passport Act of year 1967 to establish the proper procedure for issuing and for refusing the passports. Now we move towards the fact of the case. The fact of the case in this, the Maneka Gandhi, the petitioner has addressed the Supreme Court by claiming that impoundment of a passport without a good basis violates her right to a personal liberty under Article 21 of the Constitution. And Maneka Gandhi has filed a writ petition under Article 32 of the Constitution for infringement of fundamental rights which are listed in the Article 14 of the Constitution and Article 19 and 21 of the Constitution. The section of the Passport Act 10 subclause 3 subclause C is unconstitutional, alleging that section she was alleging that section 10 subclause 3 and subclause C of the Passport Act 1967 is unconstitutional. According to the section of this act, if a person has a passport and obtains another, the passport authority must impound such passports. It has also mentioned. Let's move towards the argument of the petitioners. Here, the petitioner claims that state has violated the fundamental rights of the freedom of speech and expression, individual autonomy, life, and international travels. Here they use the Latin phrase audi autem patrum, which means listen to the other side as well. The meaning of the phrase is listen to the other side as well. Refer by giving the other side the chance to be heard and is a part of the natural justice principles, and said that she had not been given this opportunity and has claimed that even through the fundamental rights embody the significance of these values even if they are not explicitly listed in the constitution. In the case of Kharak Singh versus State of Uttar Pradesh 1962, it was determined that all the rights specified in the Article 19 subclause 1 is pretending to personal liberty are included under the terms of personal liberty as used in the constitution. Let's move towards the respondent part. According to the respondent, the petitioner's passport has been seized because she needs to appear in the court to answer for breaking the Passport Act 1967 rule. The responses it also held that the government should be involved in the state's activity as a result of the party passport being seized. And the constitutional former adopted the legal process where the due process is not followed by the provision of the law which is presented in the farmer's intention, and their act should also be safeguarded. And the respondent contending that natural justice principle are unnuclear in nature and nublis in nature. Therefore, they hold that the constitution should not make reference to them. Let's move towards the judgment part of this case. The Supreme Court, seven judges panels found in the favor of petitioners, upholding that court decisions its Satwan Singh case, in which the court ruled that the right to travel abroad is protected by Article 21 of the Indian Constitution. The court gave the Constitution a fresh face, stating that the legal method must be free for arbitrariness. The court overruled the judgment in the A.K. Gopalan case and held that there is a interconnectedness between Article 14, Article 19, and Article 21. As previously, it was held that these provisions were mutually exclusive, but in the present case, the court has decided that these provisions are reliant on each other, and any case prior to the court is covered under the aspects of these articles. Now let's move towards the critical analysis of this case. So in this case, when the court overruled in the judgment of A.K. Gopalan case, the scope of fundamental right was broadened, and the judges criticized the respondent that any status is valid until it is repealed. By issuing this decision, the court has paved the way for the future cases by liberalizing the interpretation of Article 21 of Constitution, which laid the provision of basic rights outlined in Part 3 of the Indian Constitution. In today's world, the court has been successful in interpreting the various cases under the scope of Article 21, such as right to freedom from pollution, right to clean air, right to livelihood, right to legal aid, right to food, right and right to medical care, among many other dimensions. So now let's move towards the conclusion part of this case. The conclusion, basically, the Supreme Court of India's decision in making Maneka Gandhi versus Union of India is regarded as a milestone decision. Why? Because it offers a noble interpretation of this right to life and personal liberty, which is protected by Article 21 of the Constitution. The ruling has also granted the right that the scope of fundamental right shall not be constrained by national limits, and this case is also known as Golden Triangle case. Why it is known as a Golden Triangle case? Since it involves Article 14, Article 19, and Article 21 of the Constitution, which were the most important laws guaranteeing the residents of India their fundamental rights. That's why it is known as the Golden Triangle case. According to the ruling made by the court, the legal process must be reasonable, fair, and just. Additionally, the court has expanded the reach of the Article 21 of the Indian Constitution and agreed that the freedom to go abroad will fall under the purview of the court, which the court also declares that it is responsibility of the authority to interpret the Article 21 of the Indian Constitution in the way of advanced and in the way of a common good. That's it. Thank you.